My lady, I appear on behalf of the 431 appellants together with Mr. Aslett.
Yes.
The respondents are represented by Mr. Charlton, King's Counsel, and Miss Reddy, and the Information Commissioner by Mr. Christopher Knight. My lady, I hope you have, and the court has, a core bundle,
Yes.
a supplemental bundle,
Yes.
2 bundles of authorities,
Yes. Happy so far.
and an unagreed bundle running to 4 files of
Less
schedules.
happy.
I hope you have, my lady, an agreed timetable, subject, of course, to the court's view in relation to timetable.
Yes.
Only one other thing to say by way of housekeeping, which is that the respondent has, in the last day or two, added 2 authorities, or parts of authorities.
Yes.
One is the Court of Justice's decision in the case of BL.
Yes, I have that.
Thank you. And there, in addition, the respondent seeks to add some additional recitals to the 95 directive, which currently appears behind tab 1. I'm sure Mr. Charlton in due course can provide that to you.
Fine. There's no objection to those.
There is no objection to those.
All right. Yes, we've got your agreed timetable. We have extensively read into this case, both obviously the skeleton arguments and the judgments, but also I think each one of us have read extensively into the authorities and the bundles. So it may be that things can go a little faster, but you have got the 2 days. But
yes. Well, my lady, if I'm taking matters too slowly, obviously let me know.
we'll give you a nudge.
My lady, can I very briefly summarise the appellant's case, which is, as you know, that they rely on a single ground of appeal.
Yes.
Their core submission is that the judge was wrong in law to conclude that in the absence of evidence that the benefit statements had been opened, there was no relevant or real processing, and that no cause of action was made out. In order to have a valid cause of action, each of the appellants we submit needs to establish, and only needs to establish 3 things: a breach or infringement by the respondent, causation, and material or non-material damage. We submit it's clear that the appellant's data was processed by the respondent. The appellants rely on a series of processing steps and other infringements that led to the ABS being posted to an out-of-date address. The appellants we submit have a perfectly arguable case that the processing of their data was in breach of the duties and principles under the UK GDPR, and that each of the appellants has served a schedule verified by a statement of truth alleging they suffered distress or an equivalent emotion as a result of that breach, and that whether each of the appellants has suffered non-material damage as a result of the breach requires individual assessment and is a question of fact which should not be determined against them summarily. That's the appellant's case in summary. Before turning, my lady, to the ground of appeal in a little more detail, can I turn to some of the background facts and documents, taking on board my lady's indication that the court has already looked at a number of these at least. So far as the claimants themselves are concerned, as you'll have read, the appellants range in rank from police constable to chief inspector and superintendent. Some of the appellants work in higher levels of security vetting, including firearms and counterintelligence. Can I take you to the supplemental bundle, please? And first of all, if I may, to page 47. sorry, it is page 47. It's slightly confusing because there are two sets of numbers, but it's 47 in the bottom right-hand corner. What this is, my lady, is one of the templates for the ABS. It's in fact the most common template sent to over half of the appellants. You will see what's said on the first page. If I can take you forward to the third page, page 49 of the bundle, section 1. One sees personal details in the top half of the page, including date of birth, national insurance number, the date that the appellant started service with police, and details are given in section 2 of their pensionable pay and entitlement. Of course, this document reveals that the person in question is a police officer. Can I turn then forward in the bundle, please, to page 142?
Where does it say that it's a police officer? Just the reference to joining the police pension scheme 2015.
Yes.
So that's as much. So it's not that it's a police officer, it's that this person has at some point been a member of the police pension scheme. Anything else? Do the notes go with it?
As I understand it, they do, yes.
That does talk about you've been as a Sussex police officer.
It's also inferred, I'd suggest, from what is said on page 50 about continuing to contribute to the pension scheme. I appreciate, in theory, one can continue contributing to the pension scheme after one's left the employment of the police.
Yeah. Okay, thank you.
But certainly it reveals, I would suggest, that the person is, or at the very least was, a police officer.
Thank you.
Right.
Page
142. This is one of the template letters sent in early October notifying the recipient of the breach and the loss of the pension statement. This one we see from the third paragraph under the heading, "What does this mean for you?" is one where the statement had not by that stage been returned. There is another template on 144 dealing with a situation where the template had by that stage been returned. I should make clear, though, that the templates, there are various different forms of template. They're not all in the form of these two letters. There's a further example, for example, at page 212. So they differ slightly. The other thing to draw attention to in the letter, one looks at the top of page 142. You'll see the first sentence starts, "As you may be aware, it's come to our attention that a data breach has occurred." It's clear from the various schedules, and if time allowed, I'll tell you some examples, that many of the appellants had been made aware prior to receipt of this letter that a breach had occurred. in some cases, been made aware of that as early as September. You'll see in the bottom paragraph of 142 that the risk of harm arising from the breach was assessed as low, but I would submit, acknowledged that, in the letter at least, there to be some risk of harm from the incident, and that the officers in question were advised to take steps to protect themselves. One that we see in the second bullet point towards the bottom of 142 is signing up to CFAS. Much is made of that by the respondent. But I submit the force must have thought that the appellants either could be the victim of fraud, otherwise there would be no point in signing up to CFAS, or at the very least there was a reasonable apprehension that they would be. I can go on to page 146. One sees a letter from the defendant, as opposed to the force, dated the 11th of October, offering apologies for the error, and stating that Equinity appreciate this will have caused you some concern. I can take you then to page 139. There is a frequently answered questions document which was sent to the appellants in early November 2019. One sees from the bottom half of the page, the first page, the force's understanding as to how the error had occurred. And if you can look at the following page, page 140, one sees in the middle of the page under the heading, is someone able to access my pension fund, that Equinity stated they were putting in place extra security checks. Under the next question, we see they had made a decision not to attempt to recover the unreturned statements from the addressees to which they had been sent. By attempting to retrieve statements we could potentially highlight to the occupants this incident had occurred, and we wish to protect your privacy in this matter. Can I go on then, please, to page 214 in this bundle?
Sorry, just a minute. Sorry, what was that reference?
Page 214, please.
Thank you.
You should have there some minutes of the Sussex Police Pension Board for a meeting in the middle of May 2019, so some 3 or 4 months before the incident. And if I could take you forward in those minutes to page 217 at point 2.7, you will see from what is said at 2.7 that there had been a previous incident 3 or 4 months earlier in which a number of officers, 174, had their annual benefit statements sent to the wrong address. And that this had been reported to the pensions regulator. That incident, we submit, is not simply relevant to liability, it is arguments in relation to breach. Many of the appellants complain in their statements, their schedules, sorry, that by the time of the breach they had lost faith with the respondent and what the respondent was saying and whether the respondent was protecting their data. And that evidence gives some justification for that concern. So far as the addresses to which the statements were sent, the statements were sent to addresses to which the appellants had previously lived, but it's relevant to note that they were often sent to very old addresses where the person had not lived, in some cases for more than 10 or 20 years.
Well, there's reference to that in the judgment.
There is. And further, the addresses to which they were sent were often not their last previous address, and that they had moved on several occasions since that the address to which they were sent. It's argued, as you'll have seen, my lady, that by the respondent, the information in these statements was trivial or anodyne. However, we point out that the letter was sent in a letter marked private and confidential. And more importantly than that, that view that the information was banal or anodyne was not accepted by the judge. And if I continue to his judgment at paragraph 158, page, put away the supplemental bundle.
Could you give me the page number, please?
Page number 90. One sees at 158 at the bottom of page 90 that the judge concludes the appropriate time for an assessment of the evidence in relation to each of the claimant's claims is at trial. He cannot be satisfied at this stage that none of the claimants has a real prospect of surmounting the threshold of seriousness, his or her claim. The ABS did contain some information that went beyond the banal and anodyne. And he gives an example. The fact that any award of damages may be very modest if the claim were to succeed does not affect the viability of the claim. In respect of that claim, each claimant has provided details of the distress or equivalent that he or she claims to have suffered. On first impression, it might seem unlikely that the opening of the ABS could have caused much distress to a police officer, but each claimant is advancing a claim verified with a statement of truth that he or she has been caused distress or equivalent. A court could only reject evidence in support of such a claim after the relevant evidence has been tested at trial. That conclusion is premised on the basis that as a matter of causation, the only damage that is recoverable is that which flows from the ABS being opened or published, we submit that is wrong, and that's one of our core grounds of appeal. But even if the damage is limited to that which would flow from the opening of it or the publication of it, even with that limitation, the judge still considered that there was evidence that the claimants in question had suffered distress that was sufficient for the matter to proceed to trial. But in any event, it is clear the judge did not conclude that the claimants, any of the claimants, had not suffered distress. And can I also ask you to look at paragraph 159?
That's about the 14 who were allowed to go forward.
It is.
He didn't consider those issues in relation to your clients because he said he didn't need to.
Yes, my lord, but he does not make a finding that the appellants, the remainder of the claimants, did not suffer distress.
No, but he doesn't make a finding that they had an arguable claim either. He just doesn't deal with it. Your argument can be, I think probably is, that a fortiori the appellants would survive that challenge.
Yes, that is my submission. And they can't be in a worse position than those 14. I should point out in relation to those 14, they include, as an example, someone who said that they didn't suffer distress. And as I say, on the judge's analysis of those 14, it's subject to the limitation, of the causation limitation of it only flowing from the opening of the statement, which we say is wrong to apply. So, my lord is right that we do see a fortiori.
I probably shouldn't use Latin, but we all know what I mean.
I haven't followed that. You'll have to explain why the non-14 cohort, are in a stronger position than the 14 cohort when it comes to distress, whatever you say.
Well, it's not that they're in a stronger position, my lady. It is that the judge's view in relation to the 14 was premised with the limitation that the only distress for which they were entitled to recover was distress flowing from the opening of the statement. We submit that is wrong because the appellants are entitled to recovery for distress caused by a fear that it may be opened or come into the hands of a third party. Therefore, the causation restriction, determined in that way that the judge is applying to 14 doesn't apply, ought not to apply. My point is simply that even with it, the court, even with that restriction, which I submit the judge ought not to have applied, he still considered, well, even if we limit it that way, and all that we are looking at is consequences in terms of distress from opening the statement, they still have a sufficient case that it would be wrong to strike them out.
14 did.
The 14 did.
14 did.
Yes.
I mean, it's just different cases, isn't it? The judge was addressing the 14 whose envelopes were opened, and that's what he came to, and it's right or wrong, and we'll look at that. And then the rest of them, the envelopes weren't open. It seems to me it's a different point. It's not that one's stronger or less strong than the other. It's just a different factual matrix.
Well, my lady, what I would submit in relation to that is, in fact, the factual matrix for all 431 is different. They all have to be looked at individually. So to that extent, my lady, I agree with you. But in terms of the logic of the analysis, it'd be difficult to see how any different analysis ought to apply to the appellants here from the 14 who the judge considered did have an arguable case of distress.
Well, I've got the submission.
Much is made by the respondent of the fact that these are police officers who must be used to dealing with criminals and risky situations. However, as many of the appellants point out in their schedules, as police officers, they receive training in relation to risk and specifically in relation to data protection. They, or at least some of them, may have had a heightened awareness of the potential risks and have a greater awareness than the average member of the public about the potential consequences of a data breach. And we can also see from the schedules that as police officers, some at least of the appellants had a fear of being targeted as police officers. That again may have increased their likelihood of suffering anxiety or distress from the breach. But ultimately, I would submit those are issues for trial and for individual assessment of each of the cases. Can I turn then to address in a little more detail the ground of appeal that the judge was wrong to conclude that in order to have or to make out a cause of action, the appellants had to prove that the statement had been opened by a third party. And start, if I may, with the UK GDPR, which we have in tab 4 of the Personal Authority Bundle.
Put away the judgment for the moment.
Yes. So, my lady, looking at the UK GDPR, there are, as I'm sure you're aware, a substantial number of recitals. As the Information Commissioner points out in his submissions, the recitals remain part of the UK GDPR and can be used as an aid to construction. One sees from the first recital that the protection of personal data is a fundamental right. Recital 3 at the foot of page 17 refers to the 95 directive and that one of the aims of that directive was to harmonise the protection of fundamental rights. Go on to the following page. One sees at recitals 9 and 10 harmonisation, and at 10 the desirability of ensuring a consistent and high level of protection of natural persons and to remove obstacles to flows of personal data within the Union remain an aim of the regulation. And at recital 13 on page 19, an aim is to ensure a consistent level of protection throughout the Union and to prevent divergences hampering the free movement of data. I draw attention to those recitals because one of the respondents' arguments excuse me, as to why this court should not follow the post-IP completion dates decisions of the Court of Justice is that harmonisation is no longer an aim of the regulation, but that the recitals make clear that it remains an aim of the regulation and of the UK GDPR. If I can turn to recital 85 at the foot of page 20.
I don't think we're actually looking at the UK GDPR here. We're looking at the GDPR European version, which refers to member states, whereas the UK GDPR refers to the United Kingdom. I've got in front of me from another case a Keeling schedule which shows the differences I can't remember the precise
Right.
legislative
Well, that is
mechanism.
an error on the party's part,
Yeah.
my lord. Which
I think it's probably best if we just carry on with this, and any material differences can be highlighted later on.
yes,
But you've given us Article 3. Sorry, you've given us the recitals.
I've given you recital 3.
I haven't carried out this exercise, but there may be material differences. I think there will be deleting references to the member states and union and making changes which essentially reflect Brexit.
Yes. Well, I'll have to look at that,
Yeah.
my lord. That is a mistake on our part, including my part.
My lord, it might assist if I stand up. You're right, of course, that the document you're looking at there is the regulation, but at the time of the breach, the applicable law was the GDPR, not the UK GDPR, so it's not actually an error.
Right.
The UK GDPR came in after the independence date or the Brexit date, so this was the law applicable at the time of the breach.
That's an important point.
Yeah.
Thank you. Yes.
Thank you, that's
Right.
helpful.
Good. My mistake.
Oh, well, it's not your mistake, my lord. It is, and I'm grateful for Mr. Shaw in relation to that, though it may be relevant to how the court considers the issue of harmonisation.
Yeah.
Can I refer you to recital 85 at the foot of page 20, which we see states that a personal data breach may, if not addressed in an appropriate timely manner, result in physical, material or non-material damage to natural persons. Examples are given, such as loss of control over their personal data, identity theft or fraud, financial loss, etc. It's clear, of course, from the Supreme Court's decision in Lloyd and Google that loss of control cannot of itself be damage. But I'd submit also clear from that recital that a consequence of a breach may be loss of control over data, and loss of control may occur without positive misuse of the data, and it's distinct from the other examples given, such as identity theft, fraud, and loss of confidentiality. Can I take you next to recital 146 on page 22? One sees that a further aim of the regulation is that the concept of damage should be broadly interpreted, and halfway through the recital, data subject should receive full and effective compensation for the damage they have suffered. Turning to the articles themselves, Article 1 we see makes clear that the regulation is intended to protect fundamental rights and freedoms. Article 4.2, page 24, defines processing. We'll see when we come to it, the same definition is adopted in the Data Protection Act. Processing means any operation or set of operations which is performed on personal data or on sets of personal data, whether or not by automated means, such as, and then various examples are given. Clear from the use of the words such as that the list following those words is not exclusive. It's also clear from the definition that disclosure by transmission or dissemination is an example of processing, but it is that processing does not require disclosure, and that there can be processing without disclosure. The various duties are then set out. I won't take the court to those, but turn, if I may, to Article 82, dealing with the right to compensation and liability, page 37. One sees at 82.1 that any person who has suffered material or non-material damage as a result of an infringement of this regulation shall have the right to receive compensation from the controller or processor for the damage suffered. What we describe in our skeleton as an infringement claim. What is clear from that, we would submit, is that there are three and only three conditions that have to be met to have an entitlement to compensation. Proof of an infringement, proof of material or non-material damage, and proof of causation, or causal link between the infringement and the damage claim. Claim under Article 82.1 does not in fact require proof that the data has been processed, and nor does it require proof of a loss of the data. Article 82.2 separately deals with liability for damage caused by processing which infringes the regulation. And there has, again, three conditions: processing, proof of material or non-material damage, and causation. There is nothing we would submit in Article 82 which supports the existence of a threshold of seriousness. It simply provides a right to compensation for damage that has been caused. And that straightforward interpretation of Article 82 is, we submit, reinforced by recital 146, that the concept of damage should be widely interpreted and data subjects should receive full and effective compensation for damage they have suffered. Can I turn then to the 2018 Act, which we have at the next divider. The definitions are in section 3, and we see at 3.4 definition of processing, same as in the GDPR. And again, we see that disclosure by transmission, dissemination, or otherwise making available is an example of processing, but it's not a requirement for processing. So I can take you on then to section 168 on page 60. One sees at 168.1 that non-material damage includes distress. However, it does not state or suggest that the only category of non-material damage is distress. And if Parliament had wished or intended to provide that proof of non-material damage required proof of distress, you would expect that to have been said in terms. Similarly, if Parliament had intended a threshold of seriousness beyond proof of damage, you would expect that to be provided for, but it is not.
We're looking at an amended version of the 2018 Act, which refers to the UK GDPR. So does the same point arise in relation to this, as Mr. Sharland raised? We're talking about a breach in 2019.
We are, and this is the
it
version.
appears from the footnote 1 on page 60 that the amendments, which refer to the UK GDPR, came into force on IP completion date.
Yes, indeed.
And they weren't actually substituted until the end of 2020 anyway.
Yes, actually, I think you can see that from the top of page 60.
Yeah. I don't think it matters, but at least we're just noting that as we go through.
I think the only change is the reference to the UK GDPR as opposed to the GDPR, but we can check.
But what it tells us is that there was legislation. There was a legislative opportunity to make other changes, I suppose.
Yes, absolutely, my lord, which is my point, and also the point in relation to the recitals, that the legislative opportunity to remove or change the recitals could have been taken. So far as the, that is all from the authorities bundle for the moment. So far as the case law and processing is concerned, I don't intend to go through that. It's set out in some detail in our skeleton and the information commissioner skeleton. You've indicated you've looked at it.
Yep.
What I submit is clear from it is that the authorities recognise that the definition of processing is wide. Can I go back, please, to the core bundle? And ask you to turn to page 221.
Is that the skeleton argument?
It is not. It is part of the judgment of my Lord Justice Warby when granting.
Oh, right, sorry. And it's just I've got the judgment separate.
Is that 221 electronic numbering or hard copy numbering? 221 on the hard copy.
It's 221 in the hard copy. I
235.
Yeah, it's all out.
I didn't realise they were out. And I'm working from
They
hard
usually are.
They usually are. Not by that as much.
We're kind of used to it.
Yeah.
What invariably
the fact that
happens
you're used to
is,
it doesn't make it right, of course.
what invariably
Well, no,
happens
but it
is the
does make it
pagination
more
is done
patient.
without the index. So the index then adds a few pages and everything goes up.
Though, well, you'd have thought that would be a fairly obvious problem, but yes.
Yeah, and having hyperlinks at work would also be great, but you know, we don't often get that either.
Well, my lady, I understand your frustration, and I can only apologise.
No, I think it makes us more patient actually, because our expectations are so low.
Well, I don't think bad things just because they make you more patient are themselves a virtue.
Well, I agree, but hopefully it makes for a more comfortable hearing for you.
What I sought to take you to.
So my Lord's judgment at
it's
the
my
CTA
Lord
hearing.
Justice Warby's judgment on granting
Yes.
permission to appeal. Paragraph 15, in which he said it's clear that in principle an individual may establish that personal data have been processed in breach of their data processing rights without proving that the information before data had in fact been read or otherwise communicated to anyone. And he gives an example from the Facebook Ireland Insurance case. We submit with respect that he is right, and that it is clear that personal data can be processed in breach of data protection rights without proof that it's been read or otherwise communicated to anyone, and that was the fundamental flaw in the judge's analysis. My Lord Justice Warby, in the end of that paragraph, comments that examples could no doubt be multiplied. We give some further examples in our skeleton, and perhaps of note that the UI and Ostrica Post case, which I'll come to, is another example of processing which gave rise to damage without any communication to a third party. Can I go, I hope, relatively briefly to the claimant's particulars of claim, their master particulars of claim, in the amended version, or draft amended version, which appears at page 251 and onwards in the hard copy version, or bundle. And take you to section 8 of the particulars, which start at page 259. And one sees from section 8 that the appellants rely upon a series of processing steps over a period of time. The first is in August 2018, when the administrative function was transferred to the defendant, and the complaint at 8.3 is as to how the data was organised and stored, and the fact that it was stored in 2 locations. Then, again, trying to deal with this as quickly as I can. Following page at 8.4, the second step or stage chronologically in the processing is August 2019, when the defendant or respondent was supplied with up-to-date residential addresses. And in summary, complaint at 8.6 is that there was a breach by incorrectly only updating one of the locations, and also by storing out-of-date addresses. And we point out that but for this breach, processing breach, the statements would not have been misposted. And then on the following page, at 8.7 onwards, there is processing by posting each of the ABSs, processing at the point of posting. When broken down, this third step chronologically involved several processing steps. Retrieval of the data from the electronic record, printing the data onto a piece of paper, inserting the page into an envelope, and then placing the envelope into the postal system. Those are all we submit processing steps. And what we submit is that the breach in question, the failure in question of sending the ABSs to the wrong address, is really a product of a series of previous errors and processing steps. And it's artificial to look at the posting itself in isolation from the previous breaches. At paragraphs 8.9 onwards, on the following page, The particulars set out the appellant's cases to a lack of appropriate technical and organisational measures. So, for example, one sees at 8.9 that it's alleged that the respondent didn't have proper technical and organisational measures in relation to the updating of addresses. And at 8.11 on the following page, breaches in relation to how the data was stored and the fact that having addresses in 2 locations was in breach, it's alleged, of the data minimisation obligation. And the appellant's case is again that these infringements, that but for these infringements, the misposting would not have taken place, and they're intrinsically linked to the misposting. So in summary, what we submit is that the appellant's case is that there were a series of relevant processing steps leading to the misposting of the statements. But even if that is mistaken, the appellants are entitled to compensation if the infringements had been the cause of damage, even if there was no process. Though the second is very much a fallback position, because our submission is that this was indeed a process. Can I take you then briefly to the defence, the respondent's defence, which is in the core bundle at page 272. The short point that we seek to make from the defence is that the respondent admits processing and indeed admits that the posting of the statements was processing. If one looks, first of all, at paragraph 4 of the defence on page 274, paragraph 4 responds to paragraphs 3.1 and 3.2 of the master particulars of claim, which had averred or do aver that the respondents processed data, including by sending the ABSs out. And that's admitted in paragraph 4 that the respondent had processed data by, including by sending out the statements. There are various other admissions of processing here. An example is at page 285, paragraph 23 of the defence. One sees that they admit processing in relation to the recording, organisation, and structuring and storing of the address data. Indeed, the thrust of the defendant's case is that it was a data processor engaged in a number of processing steps. There is an issue as to whether the defendant was a data controller or a data processor, but is accepted by the respondent and indeed by the judge that for the purposes of the applications made by the respondent, the court should act on the assumption that the appellants can establish that would be able to establish and have a reasonable case that the respondent is a data controller.
Could you just help me about this? And I think this may be a slight red herring, but for my own information, when you were taking us through the documents in the supplementary bundle, you took us to the frequently asked questions produced by Sussex Police.
Yes.
And I'd glanced through those ahead of time, and at page 141 at the top, talks about reporting it to the Information Commissioner, and that says, please be assured that we take our responsibilities as a data controller extremely seriously. I'm just page 141.
Yes, I think that's a reference to the force taking its responsibilities as a data controller seriously. There's no dispute that the force is a data controller.
It's whether then the posting people were...
No, the issue is whether the respondent was also a data controller, and what, including, and one sees this in the pleadings, whether there's a contract in place in which the responsibilities of the defendant as a processor are explained. Which
yes, I've seen that. Yeah.
So, so far as 4141 is concerned, that's a reference to an acceptance by the force that it's a data controller. It doesn't answer the issue as to whether Equinity were also a data controller. And I don't think it's controversial that there can be more than one data controller in place at any one time.
Okay, thank you.
Can I go back then to the judgment, if I may, at page 40 in the bundle. And in particular, sorry, paragraph 4 on page 42. One sees in paragraph 4 that the judge records that the error appears to have happened because of the way in which the relevant claimant's address details were stored and processed in the database used by the defendant. So at that point, the judge is recognising that there is processing by the defendant, and indeed that processing was a cause of the breach. I can take you forward to paragraph 137 of the judgment on page 86. The judge at 137 and 138 summarises the defendant's submissions as to why the claim should be dismissed. One sees at 137 the submission is summarised as being that Mr. Sharlan contends that publication is an essential element of each cause of action. In other words, the cause of action in misuse of private information and breach of data protection. He summarises at 138 a alternative or subsidiary set of submissions that separately in his submissions on behalf of the defendant, Mr. Sharlan has made a sustained act on the trivial nature of the claims that have been brought, the wholly disproportionate way in which the litigation has been conducted, and the fact that the defendant is seeking to have the claim struck out as an abuse under the Jamil jurisdiction. I pause to make clear that it is plain that the judge accepted the first set of submissions, the ones he summarises at 137, but does not accept the second set summarised in 138.
I've been a bit puzzled by this because Mr. Sharlan's present position is that he's bound by his pleadings and that his application did not encompass the ground which the judge relied to strike out. What's your submission about the judge's paragraph 137?
Well, my submission in relation to that is that the the respondent did not seek to strike out the data breach cases on the basis that there was no publication. So it may well be that the judge misunderstood the respondent's case in that respect.
I mean, there's a passage in the defence that contains something along those lines, but it's clearly not in the application notice. And I confess that I haven't looked at the skeleton argument of Mr. Sharland. Time didn't permit. But it seemed on the face of it that the judge may have misunderstood the strands of argument that were being put to him.
Yes, I just, my lord has touched on the application notice, which is perhaps worth looking at. It's at page 328 of the court bundle. One sees, if the court has that, that this is the application that the judge was determining, that the claims in misuse of private information are dealt with in paragraph 1 and the data protection cases in paragraph 2. So far as the misuse of private information cause of action, one sees that a ground for striking them out was there was no misuse of the relevant information for which the defendant could be liable. And certainly part of Mr. Sharland's argument there is that there's no misuse because there's no publication. But that argument is not relied upon as a ground in paragraph 2 or striking out of a summary judgment in respect of the data protection claims, as we see.
Yeah. Yes, thank you.
But going back, if I may, to the judgment itself at paragraph 143, if I may, page 87 of the bundle. He deals at 143 to 145 with the claim in respect of, under the misuse of private information, cause of action. On sees at 145, he says in the second half of 145, to be entitled to any remedy, a claimant must demonstrate that he is the victim of a tortious wrong. A near miss, even if it causes significant distress, is not sufficient. So he's postulating there that the claimants may have suffered significant distress even without publication, but that isn't sufficient because it doesn't make the tort out so far as misuse of private information is concerned. Then at 146, he goes on to deal with the data breach cause of action. And states in the first sentence, the same is true for civil action for data protection. In other words, even if there is a even if distress has been caused by the breach, that wouldn't be sufficient without publication. And that, we submit, is wrong as a matter of law. And he goes on to say that if the ADS had not been opened or read by a third party, there had been no real processing. It was a near miss. As pointed out by the Information Commissioner in his skeleton, either there was processing or there was not. And the judge had previously recognised in paragraph 4 of the judgment that there had been processing which led to the misposting of the statements. So that, as a matter of analysis, is difficult to understand. But in any event, the conclusion of the judge that, or the apparent conclusion that publication is an essential element of the cause of action under the GDPR is, we submit, wrong in law. It's important to note, and I think I may have said this already, that there is no suggestion by the judge here that the claimants could not prove distress arising out of the breach. His view was that a near miss could cause significant distress, but even if it did, that wouldn't establish the cause of action. So we submit, my lady, that the judge made a significant error of law here, which gave rise to his decision to strike out the claims which was wrong in law, and these claims should not have been struck out. My lady, that's all I propose to say, unless the court has any questions for me in relation to the ground of appeal before turning to the respondent's notice.
Certainly. Thank you. Just before we move on, do you want to ask? No. Move to the respondent's notice.
The respondent's notice, my lady, we see at page 33 in the core bundle, or certainly the hard copy of the core bundle. Three grounds are relied upon. Which adopt the grounds in the original application which we've looked at. First point I would make, my lady, is that none of those three grounds was accepted by the judge. And his view was that certainly in respect of the 14 claimants, whether distress had been suffered was a question of fact that needed to be resolved at trial. And we've already had a debate as to the extent to which that conclusion has relevance to the appellants, which I won't repeat. Can I go to what is said by Mr. Sharland in his skeleton in relation to this, which is in the core bundle at page 140, paragraph 23 of the skeleton. My lady has it separately.
Thank you.
Paragraph 23, we see that it's submitted that the judge's conclusion that there had been no real processing it is suggested, or driving at a point now relied upon by the defendant as to the present claims not being sufficiently serious or capable of giving rise to a real and substantial tort. pausing there, the test of a real and substantial tort is part of the test for permission to serve out of the jurisdiction. It's not the correct test here, or relevant test here. But in any event, that is not what the judge found and wasn't his reason for striking out the claims.
I think that's part of the Jamil language, because although you're right to say that that's where that language comes from, it was adopted by the Court of Appeal in Jamil.
It was, and part of the Jamil rose in the context of a permission to serve out.
I don't think it did. I think they served on publication in this country.
Right. Well, in that case, I stand to be corrected on that.
So it was adopted by analogy, not because it's strictly applied.
I'll come back to.
I think you'll find the facts of Jamil are a tiny publication of serious allegation within the jurisdiction.
Yes, 5 or 6, from recollection. Yes.
2 of whom were the claimant's own lawyers, I think.
Yes. Yes. Though I think the use of the language, I think my Lord may have said this, the use of the language in Jamil of real and substantial tort was borrowed from.
Yes, that's where it came from.
But in any event, I submit it's not the relevant test here, nor is it one applied by the judge. It's then said by the respondent, it simply cannot be the case that police officers used to contending with dangerous and upsetting situations have been genuinely distressed over a pensions forecast sent to an old address. That, I would submit, is a very bold submission to make about claims brought by over 400 police officers, all verified with a statement of truth. And it's certainly not a conclusion reached by the judge, because he plainly took the view that the 14 claimants may have suffered genuine distress as a result of a forecast sent to an old address. I can turn to the next page in paragraph 26. It's suggested in the second sentence of paragraph 26 that the claims which are subject to the present appeal are even less serious than those of the 14 which were not struck out. But that is not accepted, and we submit is wrong. All of the claims have to be looked at individually. Only one of those 14 claimants had served medical evidence, and one of the 14 stated that she wouldn't describe the emotions she suffered as amounting to deep distress. So it certainly isn't the case that those 14 are less serious than the current appellants. It's then suggested in the next sentence, or the sentence after that, it's now common ground that none of the ABSs were read by anyone. That isn't correct. It's common ground that the appellants are not in a position to prove that any of them were read. But that is not the same as certainty that they hadn't been read. And
I know why you're saying that.
Yes, yes, I'm sure my Lord does know why I'm saying that. But it's an important point, my Lord, in the context of these cases, that not being able to prove that something has happened or having certainty about it is a very different thing from saying, well, I can't have genuine concern or distress about what might have happened to something. And one sees that from the schedules that are produced. And we submit the appellant's case is that they suffer from genuine distress from the fact that they might have been read or might be read in the future. Can I take you briefly to the order of Master Dagnall, which is in the supplemental bundle at page 411. As the court will appreciate, this is the order obtained by the respondents for the claimants each to produce a schedule. That order being obtained because the respondents' position is that the facts of each case must be looked at individually. Hence, also their application to this court that all of the schedules should be put before you rather than simply some of them. And in principle, we agree that all of the cases must be looked at individually because they are all individual. One sees from the recital of the second recital of this order that it's pointed out the claimants have an obligation under the relevant practice direction to set out concisely and proportionately details of the facts and matters on which they rely. And then on the following page, one sees the particulars that were ordered, directed, including at 1.7, particulars of damage and stress as follows, whether it's alleged that annoyance and or distress and or anxiety have been caused to him by the events complained of. I draw attention to that because one of the points made by the respondent is that all of the appellants, or virtually all of them, say that they suffered from annoyance. And that is effectively held up against them. But that, I'd suggest, is simply how the schedules were directed to be formatted by the master. And the fact that the appellants say they suffered from annoyance doesn't mean that they didn't also suffer from distress. Complaint is made by the respondent that there is some repetition of wording and phraseology in the schedules, which one maybe would have seen. Instructions were taken from all of the claimants individually. It's certainly correct that common themes emerge and there are many common complaints and concerns. I don't know to what extent the court has had an opportunity to look at a selection of the schedules. I imagine that you haven't looked at the whole of the 4 bundles, but it is...
No.
No. Yes. I wasn't expecting anything else. But
There
if
wasn't
one
a
does
reading
look
list
at...
that said we should.
Sorry?
There wasn't a reading list that said we should. I was relieved to note.
No. If time allows, I do wish to take you to a selection. Obviously, only a selection. But what is plain from
Define
looking...
selection.
Sorry?
Define selection.
Well, a small
I mean,
number.
how many?
Well, that might depend on how much time I've got, frankly, my lady. I don't... But...
You're not going to need to labour the points you want to make. But of course, you must take us to a selection if you wish to. The schedules have now been admitted. But we can be quite quick on the uptake.
Of course, I don't doubt that, my lady. But the point is that it's set against me, look, there's repetition in these schedules and a suggestion that they all say the same thing. But actually, if you look at them, and even a selection of them, they are all individual. Yes, there may be some repetition of phraseology, but they all have individual features to them. Also, procedurally, I'd point out the master did not direct a witness statement. If he had, there would have been an obligation under the practice direction for the schedules to be in the deponent's own words, but that isn't the case here. These are particulars, not witness statements, and they're not required to be in the person's own words. I'd also draw your attention to one thing that you haven't been troubled with, are a variety of statements that were before the judge from exemplar claimants to support what they said in their schedules. With those generic points, can I deal first of all with the respondent's notice and the first ground, the threshold of seriousness?
Certainly.
My lady, as you'll have seen, the appellant's position is there is no threshold of seriousness additional to or over and above the need to prove damage. And that is also, as I understand it, the position of the Information Commissioner. There is a preliminary question as to whether this issue of law should be determined now. The judge's view, you will recall from paragraph 159 of the judgment, was that this was a very interesting, to use his wording, point, that it should be resolved on the basis of facts following a trial rather than on assumed facts. And to the extent this court considers that this is a difficult or novel point of law, it may wish to adopt that approach. That, of course, is a matter for the court to consider. But I'll make submissions on it, on the assumption that the court does wish to address the legal issue of these assumed facts. The first and important point that we make is that there's nothing in the language of Article 82 of the GDPR to suggest that there is an additional hurdle. And indeed, we'd submit that the additional hurdle would be inconsistent with the clear and straightforward wording. Can I turn, I hope, relatively briefly to the domestic case law on this issue, starting with Lloyd and Google. Which is at tab 25 of the authorities bundle. And as the court will recall, this was a proposed representative action brought under the 98 Act, not the GDPR or the 2018 Act. And can I take you to paragraph 153 in Lord Leggett's judgment at page 627 of the bundle. Which is a passage relied upon by the respondent. And one sees that Lord Leggett records at 153, on the claimant's own case, there is a threshold of seriousness which must be crossed before a breach of the 98 Act will give rise to entitlement to compensation under Section 13. Now, the threshold of seriousness that's being referred to there on Mr. Lloyd's case was a threshold of seriousness in relation to the seriousness of the breach, not the seriousness of the damage. One sees that if one looks at, first of all, paragraph 88 on page 609. One sees the claimant's submissions at summarised paragraph 88. that the claimant's case was that an individual is entitled to compensation for any non-trivial contravention of the Act without the need to prove that the individual suffered any financial loss or distress. And the judge then goes on at the foot of the page to quote from the particulars of claim, setting out the claimant's case as to why it said that the breach was serious. Plainly, the claimant's case was not that there was a threshold of seriousness in relation to damage, because that would be wholly inconsistent with a contention that you're entitled to damage or compensation without the proof of any financial loss or distress. And briefly, if one looks at paragraph 115, page 617 again, we see the Lord Legate summarises Mr. Lloyd's case. That an individual has a right to compensation without proof of material damage or distress whenever a data controller commits a non-trivial breach of the requirement. So in other words, it is plain that the threshold that's being considered here is in relation to breach, not loss. Can I take you to paragraph 105, foot of 614. One sees that Lord Legate says at 105 that it would be open to Mr. Lloyd to claim, at least in his own right, damages under section 13 of the Act for any distress suffered by reason of any contravention by Google of any of the requirements of the Act. We would submit that Lord Legate has correctly summarised the elements of the cause of action, what needs to be proven are any distress or non-material damage or as a result of any contravention that is causative. I note also in passing the reference to any distress and no suggestion of a threshold of seriousness in relation to that. Can I briefly also take you in the judgment to paragraph 124 onwards? Page 619. Where the Lord Legate dealt with the claimant's, Mr. Lloyd's argument that a parallel should be drawn with the tort of misuse of private information, where the cause of action does not require proof of distress, because it was contended by the claimant that they had a common source in Article 8. And that's considered at some length by Lord Legate. At 130, he draws attention to differences, material differences between the regimes. And at 135, that there are significant differences between the privacy tort and the data protection legislation, which makes such an analogy positively inappropriate. The reason for taking you to that is because we submit that the fact that there is a threshold of seriousness in the tort and misuse of private information does not lend support to the existence of such a threshold in respect of the GDPR. And then if I can go back to the paragraph 153 relied upon by the respondent, I would submit that when read in context, Lord Leggett is referring to the concession of a threshold of seriousness, saying that even if there is such a threshold here, that it wouldn't be crossed. And in essence, what he is saying there, or concluding, that on the facts of the case, the claimants could not establish any damage and that a representative action was not viable. It does not lend support to a proposition that there's a threshold of seriousness beyond the need to prove non-material damage or distress, such as distress. Can I move next to Vidal Hall and Google, which is at tab 15.
Tab 15.
Tab 15 of the authorities bundle, yes. The court will recall this is an earlier decision by, an earlier claim arising out of the same underlying allegation of a cookie placed by Google on the Safari browser. The relevant passage in question is at paragraphs 80 and 81 of the court's judgment, page 313. Where one sees that the claimant's submission in this case was that damage for the purpose of Article 23 extends to non-pecuniary loss, where privacy rights under Article 8 are engaged but not otherwise. And one sees at 81 that that is not accepted by the court. And one see they point out that that analysis presupposed a two-tiered approach to enforcement of rights under the Act, with a claim for compensation only being available in cases which meet the Article 8 threshold of seriousness. They go on to say that it's true that the object of the directive is to protect the right to privacy, but it does not follow the plain language of Article 23, damage result of an unlawful processing operation should not be given its natural and ordinary meaning. In many cases, the resultant damage will be an invasion of privacy which meets the threshold of seriousness required by Article 8, but in some cases it will not. There is nothing in the language of Article 23 which indicates intention to restrict the right to compensation to the former. Which again, I would, although this is dealing with the Article 23 in the 98 Act, again, supports the proposition that although there's a threshold of seriousness in relation to the misuse of private information tort, not so in relation to a data breach. Briefly, before leaving Biddle Hall, can I draw attention to what's said in paragraph 92, where the court observes in the second half of 92, page 316, that section 32 prescribes the circumstances in which an individual who suffers distress is entitled to compensation. Distress is not a rare consequence of a contravention. In some cases it may be insignificant, but it is often the only real damage that is caused by the contravention. The 2 points emerge from that, I would submit. One is that distress is not a rare consequence of a contravention, and also that even if the distress is insignificant, that doesn't mean that no compensation is applicable to it. The respondent refers to Prismal and Google. I don't intend to go to that, but our short point in relation to Prismal is that it's a claim brought in misuse of private information, not under the Act, and the threshold of seriousness for a claim under the Data Protection Act was not an issue in Prismal. Can I go on then to deal with the Court of Justice case law in relation to the threshold of seriousness? In summary, submit that it is the repeated and clear position of the Court of Justice that there is no threshold of seriousness. Start, if I may, with UI and Ostraca Post, which is at tab 39. And if I can take the court forward to page 973, please. The facts are set out in the judgment at paragraphs 11 and 12. One sees from those that the defendant, Ostraca Post, had processed the claimant's data using an algorithm which led it to infer wrongly that the claimant had an affinity with a particular Austrian political party. Of note, the data was not communicated to any third party. And no third party became aware that the inference had been drawn by the algorithm. There was no suggestion, however, in the decision that that would prevent the claimant being entitled to compensation so long as he could prove damage. If I could go forward to paragraph 43 of the judgment. One sees, page 978, one sees question 3, the court was asked the question whether Article 82 must be interpreted as precluding a national rule or practice which makes compensation for non-material damage subject to a condition that the damage has reached a certain degree of seriousness. And the court's conclusion in relation to that question is at paragraphs 49 to 51 on the following page. that their view is that there is no such threshold of seriousness. At 51, the answer to question 3 is that Article 82 must be interpreted as precluding a rule which makes compensation for non-material damage subject to a condition that has reached a certain degree of seriousness. That a decision, which is decision of May 23, was then followed on slightly different facts in the case of VXAT, which is at tab 37, with the court again finding there is no de minimis threshold. To save time, Manade, I don't propose to take you through that. Can I next move then to the Court of Justice's decision in BB, which is at tab 38. The facts of this case is that a hacker had gained access to the tax and social security data of more than 6 million people held by the Bulgarian National Revenue Agency, and the claimant VB brought a claim in respect of the fear that her data may be misused in the future. The claimant herself did not know what data had been accessed. The relevant question referred to the Court of Justice is the 5th question, which we see at paragraph 75 of the judgment on page 943. The 5th question was whether Article 82 must be interpreted as meaning that the fear experienced by the data subject with regard to a possible misuse of his or her data by third parties as a result of infringement of that regulation is capable by itself of constituting non-material damage. Then on the following page at paragraphs 79 and 80, the court answered that. The wording of Article, this is paragraph 80, the wording of Article 82 does not rule out the possibility that the concept of non-material damage encompasses a situation in which the data subject invokes, in order to obtain compensation, the fear that his or her data will be misused by third parties as a result of the infringement. And towards the bottom of the page, or at the bottom of the page, paragraph 82, the court there notes recital 85 to the regulation and states, it's apparent from the illustrative list of types of damage that may be suffered by the data subjects that the legislature intended to include in those concepts, in particular the mere loss of control over their own data as a result of the infringement of the regulation, even if there had been no misuse of the data in question to the detriment of those data subjects. That, I would submit, is not inconsistent with the Supreme Court's decision in Lloyd and Google. It's simply noting that loss of control without evidence of misuse can give rise to non-material damage. Put another way, that loss of control can give rise to damage even without evidence of the data coming into the hands of a third party. The next authority take it in chronological order, would be scalable capital, a further decision of the Court of Justice in June last year. Again, I'm not going to take the court to it, but again, the Court of Justice there conclude that there is no de minimis threshold. And
Sorry, which case are we on?
sorry, it's scalable capital,
Yeah.
GmbH, which is tab 41.
Thank you so much.
Finally, in relation to the Court of Justice authorities, can I take you to BL and Media Marked, which is the judgment that was provided by the respondent last day or so. I assume this is a case where the respondent will say the court should have regard to the jurisprudence of the Court of Justice. It's in the same line of cases as a number of authorities where the respondent suggests the court shouldn't have regard to them.
Have you got a copy of that at all? I'm fishing around in my email for it. Somebody had a copy.
My lady, I can hand up a copy.
Would you?
I've got 3 copies.
Thank you.
I've got one.
Yeah, I'm fine, thank you.
Thank you very much.
I've got one, thank you.
Yep.
The facts of this case are unusual and quite specific. Can I take you to where they are set out at paragraphs 16 and 17 of the judgment? I don't know what the page number you have is for that. But paragraph 16 and 17 of the judgment start under the heading "The disputes and questions referred for a preliminary ruling." One sees that the applicant went to a retailer in Germany to buy a household appliance, and that a sales contract was drawn up. Somebody appears to have jumped the queue while he was buying the household appliance, took the appliance in question in the sales contract, but it was retrieved within half an hour without the person who took it reading the sales contract. It goes on to paragraph 28 of the judgment. One sees the questions that were asked by the referring court, and the fifth of those questions is that is non-material damage within the meaning of Article 82 incurred even where the third party who received the document containing the personal data did not read the data before returning the document containing the information, or does the discomfort of the person whose personal data were unlawfully disclosed suffice for the purpose of establishing non-material damage within the meaning of Article 82. Pause to note that there's no suggestion in the questioners referred that the claimant had suffered any distress from this, or was alleging to have suffered any distress, simply discomfort. That question is then answered by the court at paragraphs 62 onwards. And one sees at 63 the court draws attention to the unusual facts of the case. In particular here that it was known as a fact that the third party, the person who jumped the queue, had not read the data, and therefore it was known that the risk had not eventuated at the same time as the breach was discovered. This is a case where on its facts there was no possible risk, simply a breach which might have given rise to a risk in different circumstances. In other words, if it hadn't been recovered quickly, it might have given rise to a risk, but in fact it hadn't, and that was known straight away. And then one sees what the court says in its conclusions at 67 through to 69. What I'd suggest and submit is that this is simply authority for the proposition that a claimant can't bring a claim that the breach might have given rise to risk when it is clear from the outset and from the point of the breach that it did not give rise to that risk. The court are not here saying that in circumstances where it is not known that the data has been recovered, that a data subject cannot bring a claim in respect of distress arising out of that risk. And it's clear from the Bulgarian case that such a claim can be brought, assuming, of course, that the claimant can establish distress arising out of the breach.
They refer in paragraph 67 to a well-founded fear that some of the data might be subject to dissemination or misuse. That's the qualification of assault. What do you say it amounts to? Well, it seemed to rule out a fanciful concern that was completely unreal.
Well, that is introducing a qualification which does not appear in the legislation. As a matter of fact, a claimant who alleges distress arising out of a completely fanciful risk may have trouble persuading a court that there is genuine distress arising out of the breach, and one can certainly see that, but it's not itself a qualification within the legislation, which simply requires the three steps that I've outlined, and indeed Lord Leggett outlined, of breach, causation and proof of non-material damage.
Well, they go on in 68 to contrast a purely hypothetical risk of misuse which cannot give rise to compensation. So that seems to be the dichotomy. Well-founded on the one hand, well-founded fear, but on the other hand, a fear founded on a purely hypothetical risk cannot give rise to compensation, apparently because it isn't damage.
But on the facts of the case, that the hypothetical risk they're talking about is a risk that could not have eventuated because it's known at the time of breach that the document had been recovered.
Yeah, well, they're not obviously ruling on the facts of the case. They're identifying the principles.
Understood.
And their in paragraph 68, they're talking about a situation, or they at least mention a situation, where no third party became aware of the personal data at issue. I'm not clear whether on the facts of this case, the case we're looking at, it was established that the third party didn't become aware of it. A very short period in which there was an opportunity to do so.
I think that is.
Third party gets the documents and the goods, goes away. Within half an hour, they're both retrieved. But
Yes, the question is posed by the referring court. Is on the basis that the person did not read it. One sees that from paragraph 28, question 5.
yes, even if it seems, yes. Maybe some language difficulties. Anyway, thank you.
Of course, the claimant's case is, or the appellant's case, is that they do have a well-founded fear of misuse here, or certainly that their case that it was well-founded and that they suffered distress is not a case that can be dismissed at a summary stage. So in summary, in relation to whether there is a threshold, submit that there's nothing in the regulation to support the existence of a threshold, and the domestic case law does not support the existence of a threshold, and the Court of Justice has said there is no such threshold. In any event, the appellant's submission is that if there is a threshold, the issue, whether it's crossed, can only be properly resolved at trial. But as I've said, and as you've indicated, it's not possible to look at all the schedules, but I'll seek to address the main points made by the respondents. The first thing I would point out is that 41 of the appellants have served medical reports in support of their claims. There are 3 exemplar reports in the supplemental bundle. I don't know if we've had any opportunity to look at these. Can I go to page 487 of the bundle, supplemental bundle. Which is a report from a psychologist, Dr. Rosalie Hughes, in relation to claimant 317, who's a Mr. Simmons. I should say that the 3 exemplar reports we have here are prepared by 3 different clinical psychologists and intended to be representative of the medical reports. And in each case, the claimant was seen by the expert. Looking first then at the report from Dr. Hughes in relation to Mr. Simmons, page 489 of the bundle. One sees the summary and the diagnosis. And in particular, dealing with finds stress symptoms, mood disturbance, and elevated general anxiety, and concludes that the mood disturbance was attributable to the index breach. And towards the bottom of the page, second paragraph from the bottom concludes that the claimant had suffered from clinically significant distress or impairment of functioning.
Sorry, where were you reading for that? Clinic. Oh yes, I see. Last but one paragraph.
Yes, that's right. Penultimate paragraph of 489. On the following page at 2.2, details are given of the duration of the symptoms. She gives her view in relation to causation. At 492, towards the bottom of the page, concludes that the reported symptoms would not have met the threshold for a diagnosis of PTSD, but nevertheless caused distress. Then on the following page, one sees at 7.3 the anxiety-related symptoms about which complaint was made. Then at 494, at section 8, an explanation from the claimant as to why he didn't initially consult his GP. And you know what is said there about the macho culture in the police, that is reported by this claimant. Then at 498, section 13, the expert forms a view as to his reliability and veracity, and concludes, third paragraph down, no reason to doubt his veracity. And then summarises the diagnosis at the bottom of 498. So this is a person who has been seen by a clinical psychologist who has formed the view that he is suffering from clinically significant distress as a result of the breach. And the report is from an independent expert, and we see the declaration at page 501. As a further example, at 507 in the bundle, we see a report from a different psychologist, a Dr. Dix, in relation to a Mr. Daniels, who is claimant 380. At 510, we see the summary of what was concluded by Dr. Dix. Conclusion of a depressive disorder. Then at 511, you'll see what is recorded by the doctor in relation to his presentation during the interview.
Sorry,
511 of the bundle, section 3 of the report.
Oh, sorry.
Sees on page 512 at section 5.8 that he'd been taking antidepressant medication prior to the event. At 513, there's a description of why the claimant in question was distressed. You'll see there that he believes that people he detains know his full name, and given the information leaked in the data breach, they'll be able to track him down. His knowledge of the dark web, and he feels that his personal information can be sold and accessed. At 5:16, section 9, current symptoms, and at 5:19, assessment as to his veracity. Again, a conclusion there's no reason to doubt his veracity. And then causation is considered at section 15 on page 520. I appreciate I counted through that relatively quickly. There's a further report at 473 in relation to another claimant from a Dr. Willis. I'm not going to take you to that. But I do submit that the relevance of this medical evidence goes beyond the 41 appellants who have served and rely upon medical reports. The respondent's case is that it is impossible that a breach of this type could give rise to distress. In essence, as they put it in their skeleton argument, their case is that the appellants are making it up. However, it is plain that several clinical psychologists evidently disagree with them. I appreciate that the court of trial wouldn't be obliged to accept the evidence of these psychologists, and I appreciate that there may be arguments as to causation in relation to particular symptoms. However, that evidence cannot be dismissed at this stage, and I would suggest it is plain that claimants could suffer significant symptoms as a result of a breach of this type. Can I go on to deal with the respondent's categorization of the claimants in their skeleton arguments? It's paragraph 9 of their skeleton at page 128 of the core bundle. Sorry, paragraph 9 of the respondent's skeleton, page 128 of the bundle. You will see at paragraph 9 that submissions are made in relation to what happened to the ABSs of the remaining claimants. Before I turn to these, it's right to say that in the majority of cases, it is not known what happened to the statements as they were never returned, and this is dealing with categorization where there is some evidence of what happened to the statements. And one sees at 9.1, it said that there were 83 of these statements were returned unopened to the defendant by the 3rd of October, those claimants being informed of the same by the force on or around the 4th of October. And this, it would appear, is the respondent's high case on the facts as to whether these claimants could have suffered distress in those circumstances. The facts of these 83 claimants vary, and they fall into a variety of different subcategories. Some say they were notified of the breach ahead of the 4th of October and before being told that their ABS had been returned unopened and therefore suffered distress in that period. Some of them deny receipt of the letter telling them it had been returned unopened. And some explain that they still suffered distress, notwithstanding being told that it had been returned unopened, and point to a lack of trust and belief in what they were being told by the respondent. So there are a variety of different situations. Can I, without which to labour this too long, trouble you with some examples from the schedules to make good that submission? I see my lady's looking at me sceptically. Patiently. Yes.
It's disputed, is it, that they fall into those various categories?
Well, I've sought to summarise the position. It is not. There is evidence that they were sent a letter on or about the 4th of October. Some of them, as I say, deny receiving that letter. Some of them say, well, yes, I received it, but I didn't believe what I was told. And some of them say, yes, I received it, but I knew about the breach before the 4th of October and suffered distress during that period. I'm not sure that's quite saying that they are disputed, though some of them do.
Well, take us to them. We can probably spend more time arguing than looking about whether it's relevant or how much further it takes us than looking at them. So take us to the ones you want us to see.
Yes. My point, really, my lady, is that all of these cases have to be looked at individually. To some extent, that is also the respondent's case. And it is difficult to put them into clear and concrete categories and say, well, here is a situation which applies to all of these. They can't possibly have suffered distress, because it is not as simple as that.
No, understood.
The first, as an example, is claimant 198, who's a Mr. Pickering. His schedule is in volume 2 of the unagreed bundle. Starting at page 1095. You should have a 1095, a schedule for a claimant 198, who one sees at the start as a police sergeant. You look at the next page, 1096. You will see it, question 6, paragraph 6, that his case is he wasn't informed that the ABS had been returned to the defendant or the force. And you'll see that he says that he was informed that the ABS had been sent to an address he'd not lived in for the last 18 years. And at 7.1, one sees what his case is on annoyance, distress, and anxiety. that is a case, I'm not going to obviously read out what is said there, but not a case I submit that can be dismissed at a summary stage. As a further example of a claimant falling within this category, I'm afraid it's in a different bundle. It's the first bundle of these schedules. Claimant 77, page 440. So that's important 39. This is a Mr. Bell, claimant 77. You'll see from paragraph 6 and 440 what he says about notification. That he received an email towards the end of 2019 advising him of the breach, and received a further email a short time after stating that his statement had been returned unopened, and that he had at no time seen the unopened envelope. One sees at 7.1 his particulars in relation to annoyance and distress. And you'll see the third paragraph on 441, what he says about moving to a new department investigating county lines drugs. And that he says that for many months after being made aware of the breach, he was unable to sleep normally. This was a consequence of his reasonable concerns that the data would be used to identify him or his family. I don't want to labour the point, but again, this is an example of a set of factual assertions that cannot be dismissed as at this stage, and nor are they the type of case that the judge thought could be dismissed at a preliminary stage. My lady, going back to the categorisation.
Back to paragraph 9 of the skeleton argument.
Yes, sorry, that's right. Paragraph 9 of the skeleton. At 9.2, there's a reference to 18 of the statements were returned unopened after the 3rd of October, and the claimant's solicitors were informed about that in March 21. Again, I could go through a variety of claimants who fall into this category. I will try not to try your patience more than is the point of reaching its unbending point, but let me just give you one falling into this category, which is claimant 144, whose schedule is at page 816 of the second bundle. page 816, claimant 144. He's a Sapna Patel. You'll see it, section 6. What is said about the notification. You'll see that in this case, the claimant says she was advised by the defendant to make inquiries on her own behalf. I appreciate that's not what the FAQs said, but that's her position. And you'll see what's said in 7.1 onwards about her case on annoyance and distress. Halfway through 818, she points out that she remains distressed at the ongoing potential misuse of her personal information. Although she does not anticipate it was the case, there is nothing to prevent the recipient from copying down her personal details for future use. The claimant remains anxious that her details could be misused in the future. She points out at the foot of 818 that her family are identifiably diverse. And on 819, one sees the paragraph above 7.2. The claimant visited her former address at the bidding of the defendant. When doing so, the claimant was advised by the current tenant that the misposted ABS had not been received. This caused the claimant to experience further anxiety. The claimant presumed justifiably that either the current tenant was being dishonest or the misposted ABS had ended up at another address entirely.
Struck me that there's not a perfect match between the master particulars of claim in relation to damage, paragraph 12, even as it's proposed to amend them, and some of these schedules, because what's left in the master particulars are really two things: fear of what might happen as a result of misaddressing, and the those who have suffered an aggravation of pre-existing medical conditions. We've seen some examples of that. Here we've got considerable annoyance at the incompetence and high-handed attitude. And those may or may not be recoverable heads of claim, but it's not clear that they're in the master particulars.
Yes, but my lord, with respect to that, I mean, generic particulars of claim can never set out. I appreciate this isn't a group action, but can't set out every particular of loss suffered by the individual claimants. They set out what are generically claimed by all of them. That doesn't prevent the court or the individual claimant from setting out particulars of what their case is on distress, and indeed that is what's been done through these schedules. So it can't be said that the respondent doesn't know what the case is of claimant 144 in relation to that.
So
there's
one way of analysing this would be that the individual particulars are details of the generic. You're saying that the individual are extensions of the generic in some respects.
Yes, and that is common with respect in relation to generic particulars and individual particulars. That the generic particulars only set out a generic allegation adopted by all of them. That doesn't stop the individuals adopting additional particulars set out in their schedule. That I'd submit is procedurally what is intended here. I'd put it another way, my lord, that if all of the symptoms or just damage could be stated in the generic particulars, there would be no point in having the individual.
My point wasn't that you have to detail everything in the generic, because obviously not everything will be common to everyone. But I thought the purpose of the generic was to state those things that are common, and then with the details of them coming later. I'm not sure it matters very much, but I've got your submission.
Yes. Melody, I'm conscious of the time. I was going to go through individual schedules for each of the respondents' categories, and I could do if time permits. But what I do wish to take you to is one further example which falls within Mr. Sharland's 6th category.
Thank you.
So he's going back to paragraph 9 of his skeleton.
I mean, do feel free just to give us the claimant numbers or the page numbers of any ones in addition to the one you're going to take us to that you'd like us to look at later.
Well, if I may, just though I emphasise, with the risk of repeating myself, that all of these cases are individual.
Yes, well, we have that point.
In terms of the 2nd category, that's the 18 who were informed in 21 that they'd been returned unopened. Another example is claimant 412, who is a Gillian Dover, whose schedule appears in the 4th of the unagreed bundles at page 2307.
Thank you.
As regards the 3rd category, which are 60 who retrieved the schedules themselves, exemplars of that are claimant 299, who's a Mr. Mark O'Brien.
Sorry, 299.
99.
Thank you. Page.
3rd bundle at page 1647. And claimant 459, who is a Mr. Brooks, who is the 4th bundle at page 2597.
Sorry, for my note, could you give me the one, your second example of the category in paragraph 9.2, the 18 that were returned unopened after October. What was the claimant's number?
412, a Gillian Dover.
Thank you.
The 4th and 5th categories, 9, 4 and 5 are individual claimants. I propose to go to those. At 9.6 though, we have 107 claimants who it said had no recollection of whether or not they actually received their ABSs. Can I go to an example of that? The first example, in fact, which is claimant 3, whose schedule is in the 1st bundle at page 14. Page 14, claimant 3, as I say, it's a Mr. Boniface. Look at the second page of the schedule, page 15 of the bundle. Question 5, we see it's recorded the claimant does not recall receiving the misposted ABS, which is what the respondent relies upon. But it's plain when you read the schedule, what he means by I don't recall receiving it is I have no memory receiving it and don't think I did. That is plain from what you see at section 7.1. Where he talks about being unable to ascertain which address the ABS had been misposted to and confirmed it had not been received by the current residence of his parents' former address. and his annoyance that the statement may have been sent to his ex-wife. And he goes on to say what he says about distress.
General slight distress.
Yes. My point in taking to this example is to emphasise what care has to be taken with the simple statement he doesn't recall receiving it, as to exactly what is meant by that. That's what I propose in relation to those schedules, my lady. Can I deal with one point of law in relation to this raised by the respondent, which is the issue of whether there's an eggshell skull principle applies here, and the reference by the respondents to the Burrell and Clifford case. Which is at tab 16 of the authorities bundle. May recall that this is the misuse of private information claim about dealings, Paul Burrell's dealings with the royal family being provided by Max Clifford to a newspaper. I can take you to paragraph 137. Page 366. The judge sets out there some guidance in relation to assessment of quantum, which Lady Justice Ardernashee then was adopted from Mr. Justice Mann in the Galati case. And it's proposition 8, last of the propositions. My numerals right.
So tricky, these Roman numerals.
Well, they shouldn't be. Immediately above 138.
Thank you.
Where we see the principle that the extent of the damage may be claimant specific. A thinner skinned individual may be caused more upset and therefore receive more compensation than a thinner skinned individual who is subject to the same intrusion. And that to that extent the eggshell skull or principle applied. What the respondent relies upon is the further thoughts by the judge in relation to that principle at 140 to 142. And some unease being expressed by the judge as to the fact that that might result in different levels of compensation for different claimants. But although he makes those observations, if one goes forward to paragraph 159, it is clear he applies the principle and accepted that Burrell was entitled to damages for the distress he'd suffered, notwithstanding that somebody of more robust disposition wouldn't have suffered the same distress. Well, can I, and I'm conscious of the time, turn to the second ground relied upon by the respondent, which is the abuse Jamil point. The principles are set out in the judge's judgment at paragraph 111.
Could you give me a page reference for that, please?
Yes, sorry, it's page 77 of the core bundle. So at paragraph 111 onwards, he sets out the relevant principles in relation to the Jamil jurisdiction, notes that it can only be used in exceptional cases. We see that at 11.2. And at 111.4 that should it be struck out if it's impossible to fashion a procedure to adjudicate it became in a proportionate way. At 113, the Al-Saifi case, simply because a claim is only worth £50, that is not a reason for not allowing it to continue. At 115, he refers to the Mariana case in relation to a group action, and one sees from that, at 79, 176 in the judgment in the Mariana case, that the fact that a claimant or one of several claimants is acting abusively does not render a co-claimant's case as being abusive. We treat it as axiomatic that a claim brought by one claimant, which is not of itself abusive, but cannot become abusive merely because other claimants have chosen to bring abusive claims. And then at 178, it's pointed out that repeatedly stated it's only in clear and obvious cases that a case should be struck out as being an abuse. Only one other authority in relation to the principles I'd seek to take you to, which is the recent decision of this court in Muin Udin, which is at tab 33 of the authorities bundle. Which is a libel action in which an application was brought to strike out the case on both Hunter abuse principles and Jamil abuse principles. Parts that I would seek to take you to in the judgment are, first of all, paragraph 42. Sorry, should start at, apologies, start at 39, page 829, where the underlying purpose of any consideration of abuse is to prevent misuse of the court's procedure, and it follows that the power cannot be exercised if the claimant is making proper use of the court's jurisdiction. That's the essence of the abuse question. And at paragraph 42 on the next page reiterates this only in a clear and obvious case that it will be appropriate at preliminary application to strike out proceedings.
This is the general principle underlying the doctrine of abuse of process, not
it is
specific to Jamil. Yeah. Jamil is a species of.
Absolutely, my lord, that is correct. Jamil is a species of it, as is Hunter, but the general principles still apply to the Jamil jurisdiction.
Yeah.
And paragraph 81, I would ask you to look at on page 841. Where analysis is made of the off-quoted paragraph or sentence in Jamil that the game is not worth the candle. And we see Lord Reid points out that although Lord Phillips' use of the metaphor that the game was not worth a candle seems to have given rise to sorry, I should have started the previous sentence. The second point to note is that the dicta of Lord Phillips and the explanation of Jamil given by Lord Sumption in Lahoe did not import a test based upon weighing the value of the claim against the cost of the proceeding. Though the metaphor the game was not worth a candle seems to have given rise to that misapprehension, the point of the metaphor is to underline the trivial nature of what is at stake. The dicta focused upon the question whether the damage to the claimant's reputation was shown to be so trivial that proceedings could not be regarded as serving the legitimate purpose of protecting the claimant's reputation, with the consequence that the interference with the defendant's freedom of expression could not be said to be necessary. The game was not worth a candle if one wants to use that metaphor because the action could not achieve, to any significant extent, the legitimate object of protecting the claimant's reputation. So the proper understanding of the game is not worth a candle is not importing a test weighing up the value of the claim against the cost of the proceedings. That is not what is meant by it. So far as this case is concerned and the application of those principles, the judge concluded that a proportionate way could be found to try the 14 claims that were not struck out. The options in respect of those 14 cases were debated at a hearing when the judgment was given down and before the claims were settled. The options included, and some of these are touched upon by the judge in his judgment, trying liability as a preliminary issue or trying a small number of test cases. And those were viable and proportionate options in the judge's view for 14 cases. They would, we submit, be equally viable options for a group of over 400 claimants. Indeed, even more viable and proportionate is having over 400 claims would reduce the costs or the proportion of the costs of a trial of test cases as a proportion of the total value of the claim. And if a proportionate way can be found to try 14 claims, it must be possible to try 431 claims arising out of the same breach in a proportionate way. You will have seen from our skeleton that it's always been, and indeed from the judgment, that it's always been recognised by the appellants that these are low-value claims. The applicant's proposal at a pre-issue stage is to have a trial of test cases as a proportionate way of determining liability and trying sample cases on the quantum and loss issues. To facilitate that, the appellants produced master or generic particulars of claim. The respondent's position, as you've seen, is always been that the appellants must provide full particulars of each of their claims, and we see that was accepted by Master Dagnall, hence his order. But a consequence of that decision has been to increase the costs, as was inevitable by having to produce over 400 schedules. A step that the respondents were entitled to take, but they cannot, having taken that step, properly complain about the costs of it. You'll have seen also from the judgment that the parties were directed to produce budgets, cost budgets, for a trial of lead cases, and the respondent's budget was slightly higher than the appellant's budget. The figures are given in paragraph 12 of the judgment. But in any event, we submit, if the court considers the costs are excessive, it has a power to disallow them or budget them. The correct course, however, we submit, is not to strike out the cases. Indeed, we submit that it would be a sad indictment of our legal system if a proportionate way could not be found to try the claims of over 400 people claiming damage arising out of the same breach, even if those claims are individually small. My lady, I still have to deal with the third ground, which I think I'll be able to deal with relatively briefly. I wonder, I know it's not quite 1 o'clock, if it's convenient to allow me to look at my notes over lunch as to whether there's anything else I need to address before dealing with the third point briefly at 2 o'clock.
No, that's not a problem at all. Very well, everyone. Thank you very much indeed. 2 o'clock.
Court rise, please.